Hi, everyone. Thank you for joining us today for Constangy's webinar, Remote I-9 Verification, What Employers Need to Know About the New Remote Verification Process and the New Form I-9. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. This program is approved for SHRM and HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow afternoon. I'm now going to turn it over to today's presenters, Penny and Justin.
Thank you. Good afternoon, everyone, and welcome to our webinar on the new remote I-9 verification as well as the new I-9 form. I'm Penny Bradshaw, the co-chair of the Immigration Practice Group, and with me today is my partner, Justin Coffey. As I think most of you know, immigration law is federal law, and although Justin and I both sit in North Carolina, Constangy has national coverage of immigration with teams in a number of different cities, and we're available to help you not only with all types of employment-based visa matters, but also with I-9 and E-Verify compliance. Justin, for example, has practiced in New York and Georgia prior to coming to North Carolina. We are going to try to take questions in the chat as time permits, but there will be an email address at the end as well, so that if we don't get to your question, you can go ahead and submit that, and we will get back to you with answers as best we can. Let's turn now to today's agenda. What we're going to do is discuss the new virtual option for reviewing I-9 documents. This is something that actually practitioners and employers have been urging the federal government to put in place for years now, and it actually took a pandemic for the government to realize that it is a viable option to look at documents remotely. But with the virtual option comes some new and additional obligations that may not fit all employers. And so one of the things we'll focus on today is, how do you make the decision for your company what's best? Do you want to use this new optional remote procedure? Do you want to use it for everybody, for some places? And how can you do that in a way that won't get you in trouble in terms of overall compliance? We're going to talk about the major changes to the new I-9 form. For those of you who've seen it, and most of you I think have, because it's been in effect since August the 1st, it's much more user-friendly. The main form is on one page. We're going to talk about the instructions. They've also been simplified. And then we're also going to touch on the end of the COVID-19 flexibilities, also known as the interim waiver of the in-person document inspection requirement. Actually, the deadline to do that and come into compliance by looking at documents was yesterday, but it's not too late for you and your company to continue those efforts if you've not completed those. And so we're going to talk a little bit about how to do that as well. So let's talk a little bit about the background of the I-9. For those of you who've been in HR a long time, you know that as of November 7th of 1986, the I-9 form was required for all new hires. And it was part of the Immigration Reform and Control Act, or IRCA, which was passed under the Reagan administration. And their Congress did two things. They put a path in place for certain undocumented people to get a legal status. But they also realized that the reason that we had millions of undocumented people was in large part because folks were coming here for work, coming here for a better life, perhaps coming here to work and send money back to their home countries. And so the idea was that employers would actually be put on the front line of immigration enforcement by being required to vet the identity and work authorization status of all new hires. Now, the thought was that that would discourage folks from coming to this country who weren't authorized to work. But in fact, as many of you know, it spawned a cottage industry of bogus driver's licenses, bogus Social Security cards, and all kinds of issues that HR folks face every day in terms of I-9 compliance. But the rule has always been, until recently, that you had to physically inspect the documents. And what the Immigration Service said was that was a tactile, a touching, looking at the documents, and it was supposed to be done in the presence of the employee. Now, both Justin and I have worked in compliance issues for years and years, and it is not at all unusual for us to come across employers who weren't complying technically with those requirements. So, for example, an employer may have multiple locations. They may have a local person look at the documents, but then scan them or copy them and send them to headquarters, where somebody else would actually complete and sign Section 2. And that's problematic because the employer representative was attesting to the fact that he or she actually physically looked at the documents. And in fact, it says under penalty of perjury, which the government takes very seriously. So this physical inspection requirement has been something that is really key to the entire process and your being in compliance. What happened was when COVID hit and so many businesses closed down, and in a lot of places it wasn't voluntary. There were cities and states where the government said, unless you're an essential worker, you can't come in. We don't want you in the office. Everybody work from home. But here we have IRCA, the Immigration Reform and Control Act, which still required employers to vet the identity and work authorization of all new hires. So what was an employer to do? So fairly early on in the pandemic in March, the government announced that they would have temporary flexibilities for COVID-19. And basically what that meant was that you could do a remote inspection. And it could be, a Skype or a Zoom, but it could also just be looking at copies or scans of the documents. And the idea all along was that this was an interim temporary waiver of the in-person inspection requirement. It was never intended to be permanent, and it was never intended to be the end of the I-9 process for those new hires during the COVID flexibilities. And so what happened is the government several months ago announced that they were ending those flexibilities and that we would have to go back to the in-person inspection. And in fact, the initial announcement was that employers would have to do an in-person inspection of the documents for all of those new hires that came on board during these temporary COVID flexibilities. So the actual date the exemption ended was July 31, and employers were told that they needed to complete these in-person inspections by August 30. We're going to address this a little later in the presentation, but it's not too late for you to come into compliance if you did not meet that deadline. That's something that's still very important for you to do. But then the government issued new regulations effective August the 1st that for the first time allowed a true remote verification process, but only if the employer met certain qualifications. So let's talk a little bit about what's necessary for folks who want to use this new process. The idea is you have to be a qualified employer, okay? And so what does that mean? If you're a qualified employer and you're going to use the new process. Justin's going to talk about this in more detail, but the bottom line is you have to be an E-Verify participant, okay? So how do you do this new virtual process? The new hire can complete Section 1 remotely, okay? And that can be done paper, or it can be done using the PDF version that's available for free online, or it can be used with any kind of electronic I-9 system. And many of you probably have electronic onboarding systems, which not only collect information from the new hire, but also have the new hire go ahead and do their I-9 form. And perhaps under your current system, it may have them upload their documents, okay? But what the rules are if you're going to use the new virtual process, and the timeframes track the traditional process that's been in place since November of 1986, which is that the employee has to complete Section 1 no later than the first day worked. And then the employer actually has 3 days after that. And we actually call that the Monday, Thursday rule to help people count that. But you've got 3 extra days to actually do this inspection. But it's not just a remote inspection by Skype or Zoom or Teams. The first step is that the new hire has to provide soft copies of the documents. I see a question here. Yes, we are offering SHRM credit, and we will have the codes for that at the end of the presentation. Thank you for that question. But the new hire has to provide copies of the documents front and back, okay? And that's done before you do this new virtual inspection of the documents. And they do want you to see the front and the back. And why is that? When we do trainings on I-9 and best practices, if you have a document that might turn out not to be genuine, oftentimes there are things like misspellings or some characterizations on the back of the document that will give you more of a clue that it's bogus, as opposed to the front of the document looking real. Okay, the employer's obligation remains the same as it always is. Is the document related to the person, and does it appear to be genuine? And it's sort of a reasonable person standard there. Then after the employer rep has done that inspection of the soft copies, that's when you have to do a live video interaction with the new hire. And at that time, the new hire actually presents the documents, and they do it just like this. I've actually tested it out. You know, you can hold up a driver's license, hold up a passport. And with most folks' cameras, you can see that pretty clearly. But the idea is the employer rep is going to have the documents already so they can look at them. We're going to get to the question about the 3 days to complete in a minute. And what we'll talk about, though, is it is a best practice to do the entire process on day one. Okay, so you do this live interaction, and you're also supposed to make sure, again, that the document relates to the person, and you're going to see the person on the screen, and you're going to look at the documents. Okay, now there's always been an issue of the person's photo on the document might not look like the person today. Okay, the driver's license may be 7 years old. The person may be balding. The person may have gained or lost weight. But again, it's a reasonable person standard to determine whether the document is related to the person. And then you complete section 2, or if it's a re-verification, and we'll talk about that a little later, supplement B. And importantly, you will check a box that indicates that what they're calling the alternative procedure was used. Okay, and so that is the change if you're going to be using that. And you do retain copies of the documents, all of the documents presented if you use this alternative procedure. For those of you who are already enrolled in E-Verify, you already know that you're required to keep copies of List A documents. Okay, but you will have to keep all of the documents, whether it's A or B and C, if you're going to be participating in the new procedure. Soft copies means it can be a scan, it can be a fax, it can be a photocopy. All of those would be acceptable soft copies of the documents. So let's go to the next slide. Okay, let me turn it over to Justin to talk about, what is a qualified employer and what are the actual requirements? What are your compliance issues if you want to use this new remote verification process? Justin?
Thanks, Penny. And before we go into that, I think just based on some of the questions I see coming through, maybe we should just do a quick recap, because I know it's a lot of information and it's a brand new process that a lot of people have questions about. But just a quick recap of the basic process here, right? So the first thing that happens is the employee, the new hire, completes section 1 of their form remotely. Then within 3 days, they select the documents they wish to present. They send them through some electronic method, right? The employer reviews those documents to ensure they appear reasonably genuine, then conducts a live video interaction. And one of the questions I saw come through was, even if we get these through our normal process, or do we still have to do a live interaction? Yes, you do have to do a live video interaction. And the live video interaction, as Penny mentioned, is to ensure that that document reasonably appears to relate to the person presenting. Okay. Then, assuming that it does, then the employer will complete section 2, unless it's a re-verification, and retains copies of those documents. All right. So who is a qualified employer, right? Because not all employers can take advantage of this process. And I know many employers want to. but you have to be a qualified employer to utilize this new alternative procedure, as DHS is calling it. So you must be enrolled in E-Verify, and you must be in good standing. And we'll talk a little bit later about what good standing might mean. There are new fraud and anti-discrimination training modules in E-Verify that must be completed. And the employer must be enrolled in E-Verify at all of the hiring locations where the virtual process is going to be utilized. And the employer must use the virtual process consistently and in a non-discriminatory manner at each hiring site. So, Penny, do you want to talk a little bit about what that means?
Yeah, I mean, you've got to make sure that you're not discriminating in some way. And as those of you in HR well know, you can unintentionally discriminate against somebody if you have a policy or practice that has a disparate impact on a protected group. And so you'll want to make sure that as you're offering this procedure, that you aren't discriminating against particular groups.
So
So,
Penny, let me ask you, sorry, let me ask you a question. For example, let's say there's an employer that is very compliance oriented, right? They want to make sure that they don't have unauthorized workers in their workforce. They want to offer this virtual process at their hiring sites, but they have a hiring site where they've had a history, perhaps, of seeing a lot of fake green cards. So the employer wants to offer the virtual process to all employees at this hiring site, but for green card holders, they want to require those particular individuals to come in and do an in-person physical verification. Do you see any concerns there?
you absolutely cannot do that. You're asking for some steep fines, either from ICE or the IER, which is the agency in Washington in the Justice Department, which handles discrimination based on citizenship and other status. There have been other cases that have come up prior to this new process where employers have asked that very thing. They've wanted to see the green cards, and the choice of documents, and this goes back to November of '86, has always belonged to the worker. And the employer, not only can they not require that certain documents be shown, they can't even suggest it. And so to go that extra step and saying, if you have this one particular status, we're going to make you come in and show your document. Part of the reason why that's problematic as well is that the instructions clearly say that you can't require the new hire to show any kind of documentation to support which of the 4 boxes they check in section 1. We've got citizen, national, permanent resident, and persons authorized to work in the US, which is sort of the others. And it makes it very, very clear that although you need to look at documents to make sure the person is who they say they are and that they're work authorized, you've never been able to require the person to show any documentation to demonstrate, show me your passport, you're a US citizen, show me your green card, you're a permanent resident, etc. So again, that's something you'd want to stay away from. Let me ask you one, Justin. How about if, you have a new hire and their location is one where you're doing the remote, but then that person says, I'm not going to send you my Social Security card by email. I don't feel like it's secure. I'm glad to bring it in, but I just refuse to do that. What then?
Yeah. So an employer cannot demand that the virtual process be used. So if an employee is not comfortable with that process, if they're not comfortable providing their documentation electronically, if they're concerned about the security of their Social Security card, etc., the employer cannot require it. So if an employee prefers to have an in-person physical verification, the employer must accommodate that. So that is one thing to consider if going to this virtual process. If an employer is thinking, well, we'll only use the virtual process, we'll never have in-person physical verifications occurring again, be aware that you may have to accommodate that.
Right. And be aware there is a workaround to that, which I think most of you are familiar with. And I always call this the traditional remote I-9. And that means that the employer can designate an agent to do the inspection of the documents on its behalf. So if this employee that Justin and I are talking about, who won't send his Social Security card via email, wants his documents reviewed in person, it is an option to use the agent. And you basically can send an instruction sheet to the agent saying, you know, we're asking you to complete section 2 and give them instructions on what they're supposed to do, what they're supposed to do after they complete the form. That's always an option. Now, you know, some employers are hesitant to do that out of a worry that they're responsible for you know, the agent doing things correctly, and so that is a concern, but that remains a viable option despite this new remote procedure. You can always do a one-off traditional remote I-9 with an agent.
Well, and a question that came in related to doing in-person verification was, if we're doing in-person verification, not utilizing the virtual procedure, as they call it, can they see soft copy documents, or does it still have to be original documents? And just to be clear, this new virtual procedure is an additional option, but it doesn't change the current in-person verification process. So if you're doing an in-person verification, you would see original documents as opposed to copies.
Right.
The other thing to note too is that while you do have to use this virtual process consistently, and you do have to offer it to all employees at the hiring site where you're using it, you do have the option of using it at a hiring site only for your remote employees, and requiring all your employees that are working in person or hybrid mode to come in for in-person verification as well.
We had a question about using a vendor as an agent, and that's perfectly fine. We do have some clients who, for example, have a vendor that handles their background checks or handles other parts of the onboarding process, and it's perfectly fine to use a vendor for that process. We also, I know, had a question earlier about, you can use this process if you have a vendor that does your E-Verify. Some of the electronic I-9 programs have the employer rep complete the process with the employee, but then the system automatically submits the E-Verify case, and that is perfectly fine to have that. What we found is that a number of the vendors don't yet have their new systems with the new form, and especially, you know, interfacing with E-Verify up to speed, because I'm sure it needs a lot of coding to do that. And so we do have until a particular date, Justin probably knows it, in October, to start using the new form. But I think those are going to start coming live with the various vendors now who are going to be offering that same service to their customers who want to use the remote I-9 alternative procedure.
Yeah, Halloween is our deadline. So
okay, that's
November. Yeah, Halloween, November 1st, the new form is required. Until then, we have a grace period. So just remember, Halloween is your deadline. Yeah. So in looking at this process, right, this virtual process that I know many employers are very interested in, because particularly since COVID, we have more and more of a remote workforce. There is a lot to think about, right? There's a lot of considerations in terms of using this virtual process. First of all, the basic requirement is that you must enroll in E-Verify. And I saw some questions come through about this. You are not eligible to use the virtual process unless you are enrolled in E-Verify. And enrolling in E-Verify, DHS will tell you, is very simple. It's a very simple program. It's very easy to administer. What's your thoughts, Penny? Is DHS accurate in that, or are there things employers should be considering before enrolling in E-Verify if they're not currently enrolled?
DHS has a mindset of wanting to encourage employers to enroll in E-Verify. So yes, they're definitely going to stress how easy it is. But as we'll talk about a little bit later, there are pros and cons of enrolling, and there are additional administrative burdens, and folks just need to be aware of what's involved if you do enroll and staying in compliance. So it's definitely something that you want to think about before you do it. And there are also some rules about being able to enroll only in certain locations. I'm guessing that a number of our participants today are with companies that are in multiple states, and some of them may do E-Verify nationwide. Others may just do it in the states in which it's required, and we're about on the cusp of half the states requiring it in some fashion or not. It's long been required for certain federal contractors, but there are considerations of whether you want to become a part of the program. I will say, getting a little into the weeds, that those of you who work in this area know that without E-Verify, you don't have a whole lot of assurance that the person that you've done the form for is actually authorized to work, okay, because of very real but bogus looking documents, what I call identity sharing that's going on. But again, it's not something I would just assume, oh, we're going to sign up for E-Verify so that we can take advantage of this new remote process. Yes, a PEO can be the E-Verify agent and do that for a company or a group of companies. And there are a number of major vendors out there that offer that service as well.
And so for employers that may not be familiar with E-Verify, may not already be enrolled in E-Verify, I'd recommend that you take a look at the Memorandum of Understanding, the MOU, that an employer must execute with DHS to be enrolled in the program, to understand what your responsibilities and obligations are under the program. And that MOU is available publicly on the USCIS website. And there's an E-Verify handbook, user guide, that you also might want to take a look at, because it's pretty extensive and pretty detailed for a program that's supposed to be fairly simple to administer. If you review that guide, you may find that it may not be as simple as you think. And of course, I'd recommend you talk to your counsel before enrolling in E-Verify to get their guidance to see whether that might be a good fit for your company. The other thing I'd mention too is we are aware that if you use E-Verify, right, you are giving DHS a window into your hiring data. And Penny, do you have any experience with DHS looking at hiring data?
They do. It's actually primarily the IER, Immigrant and Employee Rights section in the Justice Department that is sort of like a mini EEOC in this area. And what we have seen over the years is that they will literally troll the E-Verify data. And if they see something that they think looks off, they can start an independent investigation. Most of their investigations are claims driven, similar to the EEOC, but they can do their own. And what I saw over a period of years was there were staffing companies who were investigated because the people at the IER trolling that E-Verify data felt like there were more than the normal amount of List A documents being presented, green cards in particular. In other words, the idea is a person who's a permanent resident, yes, they have a green card that they can show, but they also would likely have a driver's license or state ID, and they'd have a Social Security card that's unrestricted. And so the idea is that statistically, some amount of permanent residents would likely show B and C documents and not A. And so the folks at the IER were doing investigations because they had concluded that the employer had an abnormally large percentage of List A documents presented by permanent residents, and they made an assumption that there must be some discriminatory intent, discriminatory process in place. So that's just an example. I mean, they control other types of documents, but you are leaving yourself open, as Justin mentioned. They can see all of your information on your new hires, everything that goes into E-Verify, which is a lot of the information that comes off the I-9 form. So again, just something to be aware of, big picture, as you're deciding whether it's worth it to enroll in E-Verify solely to be able to take advantage of this new procedure. Again, many of you are already required by the states in which you're doing business to enroll, but for those of you who are not, that is an additional consideration.
Yeah, so be aware that DHS has executed memorandums of understanding with other government agencies to share their data. And as Penny was saying, they will mine that data and share it with other agencies. And for example, the situation Penny cited, if they see a lot of green cards being presented, they may be concerned. They may think that the employer's demanding to see only green cards, which of course is a prohibited practice. And so if you enroll in E-Verify, be aware you could find yourself under investigation if they're looking at your data and have some concerns. Now, we did get some questions about what does it mean to maintain good standing in E-Verify. There is a definition in the regulations. It's not particularly helpful. The definition says something along the lines that maintaining good standing means that the employer is complying with all of the E-Verify requirements, which are met, okay? So we don't know exactly what that means, but if an employer is struggling to comply with the E-Verify requirements in a timely fashion, then this is something to consider. For example, if the employer is struggling to initiate E-Verify cases timely, right? If you're submitting cases late or not resolving TNCs, tentative non-confirmations, in a timely fashion, not closing cases correctly. These are things that potentially DHS could say are not compliant, and that
Not
maybe
closing cases can just be a training issue, right? And
Yeah,
you might not, the head of HR might have no idea that one of the HR assistants hasn't been closing the cases.
and we see many cases, many situations where cases are closed incorrectly, where someone's closing cases indicating that the employee is not authorized to work and they continue to employ them, which of course is going to create a flag with DHS. And they, in the E-Verify program, they became much more aggressive in tracking this and contacting employers to say, you're not in compliance and you must get into compliance. And if you don't get into compliance, we're going to suspend you from E-Verify. And I have seen that occur where employers have been suspended from E-Verify for not doing things such as resolving their TNCs and closing out their cases in a timely fashion. And if you've been suspended from E-Verify, I think it's safe to say you're not in good standing. So hopefully in the future, we'll get a little bit more guidance about exactly what that means. But if you're not in good standing, then DHS would say you're not eligible to use this virtual option. Okay. Some of the things I think in thinking about using this virtual option, assuming your company's enrolled in E-Verify already, is you're going to have to create a program to manage this, particularly if you're a large employer. If you're a smaller employer, this may not be as much of an issue, but for larger employers, you're going to have to create a program, a process around this. You're going to have to be able to conduct these live video interactions within that 3-day time frame. And you're going to have some kind of tool to do that, whatever it is, Skype, Zoom, Teams, there's many out there, but you're going to have a process for conducting those live video interactions and doing that within the required time frame. You're going to have to be able to have your employees send you documents in a secure method, right? You're going to have employees sending things such as social security cards. So you're going to have a secure method to receive those documents. This process has additional requirements above and beyond the standard I-9 verification process, So that means there's more things that the government can audit you on, right? There's more things to potentially get wrong and to have the government audit you on. For example, and Penny will be talking about the new form, but for example, there's a box you check to indicate you use the new alternative procedure. What happens if you forget to check that box? Is that a technical violation? Is it a substantive violation? We don't know yet. I suspect they might say it's a substantive violation. We'll find out. But these are more things to come under scrutiny and to be in compliance with. And you're going to have to figure out which hiring sites you want to use this virtual option in, and how are you going to use it at those hiring sites? Is it going to be available to everybody, or you can have it available only to your remote workers? So with that, Penny, do you want to touch on the new form?
Jump right into the new form. And I guess most people have seen this. You know, it harkens back to years ago when the original form was 1 page long, and then it got longer and longer and longer, and it's actually gotten simpler. Although substantively, it's really not that much different, other than it does have the place now to indicate. You can say check here if you use the alternative procedure, and that's in section 2. Just some best practices here, especially for those of you who use paper I-9s, is you're going to want to make sure it's filled out correctly and completely. The instructions actually tell the employer rep that you should look at section 1 after the employee's completed to make sure it's been done. But ICE audits are still a thing, okay? And, you know, if you have folks doing new hire paperwork, and especially if they're doing it remotely, you want to make sure that you're taking a look at the form and making sure it's filled out correctly and completely, in addition to being on time. And that includes things like, you know, checking one of the 4 boxes and putting in whatever kind of USCIS or A number, I-94 number, whatever's called for, making sure that that's done, okay? Because we know from years of working with ICE on audits that they consider all of these fields to be very important. One piece of good news is they're not saying that you have to put not applicable in the fields that you're going to leave blank. I've had lots of discussions with employers over the years that were doing, let's say, an internal audit, and they were trying to make their I-9s as perfect as can be, and do we have to have the employee come in and write not applicable all over the place? And no, you don't need to do that, but do make sure that all the information is filled in. Just let's go back to the last slide for a minute if we could.
Oh yeah,
thanks. But what the government looks at in terms of the errors that they consider to be really important are not only the things such as checking one of the boxes, right, or putting the date when somebody's work authorization expires, but not signing and dating, okay? And I would direct your attention to the attestation wording on these, which has been there all along since back in 1986. But you're attesting that the information is correct. And if you don't sign, then that's considered to be very serious, because the government's going to assume that you're not signing because something isn't correct. Now, we all know that they didn't sign because they were filling out a ton of new hire paperwork all at the same time, and somehow they forgot, right? Same thing with not dating the form, because the government says the date on section 1 is the only way that we can tell if the employee completed the form on time, which is, again, no later than the first day that they work. So, you want to make sure that all of that's done. Same thing in section 2. We don't see as many issues now because it's a lot more clear that you may have more than one document for which you need to put the document title, the issuing authority, the number, and the expiration date. But I would commend to you, if you're still using a paper I-9, the PDF that's available online for free. And it's not an electronic I-9, although you can fill it out on a laptop, right? And then you can save it and print it, and then you retain it like you would a paper I-9. But the beauty of that is it has the same drop downs as you can find in the electronic systems. In other words, most of those systems, if you put in a list A document, it won't let you move from that until you put all the information. And it won't let you go on to put a list B and C document, okay, which would be over documenting your case, which you can get fined for as well, okay. And it has drop downs like driver's license, issuing authority, just list the state. And so it just makes it a lot more user friendly. So I would just commend that to you for consideration if you're still using what I'll call an old fashioned paper I-9, which is perfectly fine, but you might want to consider using the PDF that's available.
Penny, someone's posed this question a couple of times, so maybe we can address it.
Sure.
They've asked if office personnel is filling out section 1, can a different office personnel fill out section 2? And just to clarify, section 1's completed by the employee, right? And not by the employer. Now, related to that, often there's a question as to, can different employer representatives look at the documents, then complete the form? What's your thought on that?
Yeah, that's a no-no, because the person who signs that form is attesting under penalty of perjury that they examined the documents. And so I know that an example would be, somebody that's local in a small office looks at the documents because the company wants to be compliant and then sends them, scans them, whatever, to headquarters, where somebody completes section 2 and signs it and then maybe runs E-Verify. Now, the E-Verify part is fine because you don't have to have seen the original documents to run the E-Verify case. But if you're signing under penalty of perjury, you don't want to be doing that. And where that can come up, Justin, is, if you've got the person that's signing, you put your title and the company's address, and let's say the company's address is in Florida and the employee's home address is in Missouri. I mean, that's a red flag. That maybe, just maybe, the person from Missouri did not travel to Florida to do the onboarding process. Okay, so I like to call these traps for the unwary. But yeah, good point is, just be careful that you actually are being compliant, because you don't want to get into a situation, if you get an ICE audit, you would have to disclose your actual processes. I mean, no counsel would advise you to do anything other than that. So even if you've done it wrong in the past, today's the day that you start doing that correctly. So go ahead.
I was going to say another question we're seeing is on the retention period for I-9s, right? And so that is 3 years from the date of hire, or 1 year after employment ends, whichever is later. And there are calculators for this. I think even USCIS may have one now online to help you figure that out. So you might want to use one of those calculators to make that easy for you.
Yeah, a best practice that actually I had a participant in a seminar I did one time suggested is, anytime somebody's termed, go ahead and calculate that retention date and write it on the form. Or, if you have an electronic form, you probably have a notes section, and the new instructions actually say that that's one of the appropriate things that you can add on in a notes section. In addition to, for example, an E-Verify case numbers, you can add in the retention date. So something to think about just in terms of some best practices. So let's move on to the next.
Okay, one more question, if you don't mind. Another question we're getting is about the best practices to correct errors in section 2. If you're doing internal audit, you find there's, for example, an incorrect document number or something in that nature, what's the best practice to correct that?
Yeah, what you want to do is make your correction, and the government doesn't want you to use whiteout or obliterate what was there before, draw a single line through it. Write in the correct information and initial and date in the margin. If you think that the correction needs some explanation, then it is perfectly fine to do a memo, or to even write a note on the bottom of the I-9 form as a paper I-9, because what you're thinking about is, if I have an ICE auditor that's looking at this I-9 and he or she's going to see something that appears to be a disparity, and you might want an explanation, then that's the type of thing where you might want to actually add a note. But what they want to do is they want you to disclose that you have made corrections. And on electronic I-9s, they actually want to have an audit trail It's a requirement for compliant electronic systems that somebody be able to see who went into that I-9 and who made the change and when. So, most of the professional systems out there are pretty compliant, but again, that might be something you'd check with your counsel on, because obviously there are some more compliant to others. I noticed a question about the retention period. It's not 1 year after termination. If somebody is hired and you fire them 3 days later, they're the worst employee ever, you're going to keep that I-9 for 3 years. Okay, it's the longer of 3 years or 1 year after termination. Were there a couple other questions, Justin, that I missed coming in?
We're getting a lot of questions. I'm not sure we can handle them all, but we don't have all afternoon.
Sure.
I just see one here about whether you're permitted to use the new form, even if you're not using the new virtual I-9 process. And yes, the new form and the new virtual process are not one and the same. Though the new form allows you to indicate you've used the new virtual process, but yes, not only can you use the new form if you're not using the new virtual process, come November 1st, you must be using
the Halloween
new form. Yes, the Halloween. Come Halloween, you should be using the new form.
Okay, so again, the changes aren't all that dramatic, but what they did is they put section 1 and section 2 on a single page, and that just makes it so much user friendly, because depending on your industry and your workforce, you may seldom have anybody that uses a preparer or translator. You may seldom have people who need re-verification, and so the idea was to simplify the form, and instead they now have supplements. And supplement A is the preparer translator. It's the same as you've seen before. Okay. If somebody doesn't have sufficient English skills to know what they're being asked to write down, you'd be using a translator in most cases. If people lack literacy skills or maybe keyboarding skills, depending on the kind of I-9 system you're using, you might also use a preparer. But a caveat there is that you can't use a preparer as a substitute for the employee completing section 1. And Justin touched on that a few minutes ago. To save time, you can't have an HR assistant sit there and keyboard in the stuff for everybody if they're capable of doing it themselves. And that's one where, again, the government can look at the percentage of forms where you have preparers or translators, and especially if the person, maybe even just by their last name, appears to be someone who might speak English. Just be aware of that, because you're not supposed to pre-populate the forms. That's a rule that's been around for decades. I once saw a company that, to save time on their paper I-9s, had typed in on an I-9 form, driver's license, social security card, social security administration, thinking that then the person wouldn't have to fill that in and could save time. And that's a violation, because that equates to either suggesting the documents they have to provide, or even requiring that they provide those documents. So again, just be careful in using the preparer.
And I'll just mention, Penny, quickly, that part of the thinking, as I understand it, in moving the preparer translator into a supplement off of the main form, was that it's not widely used. It's not so commonly used, so we'll just move it off into a supplement. So I think the government's not expecting to see that used with a lot of frequency.
Right, and if you don't use it, you don't have to keep it. Okay, same for the supplement B. That's the re-verification. And again, depending on your workforce, you may have very few re-verifications. Those of you who have a lot of foreign national professionals, like on H-1B visas or L-1 visas, you're probably very familiar with that. But also the DACA, Deferred Action for Childhood Arrivals, TPS, all kinds of parolees, folks from Ukraine and other countries. There's a whole lot of different categories now of people who have work authorization, which typically has some sort of an expiration date. It is definitely a best practice to track that. Most of the electronic I-9 systems have what we call a tickler or reminder system in there.
And if they don't, they should.
Right. To say this is expiring. The one deficit that I see in some of those is often they don't send that message until, let's say, 30 days before a work card expires. And unless somebody's in a special category of work card with an auto extension, that's not enough time to get a work.
And some of those systems allow you to change that. Some of them can be customized so that if it's default at 30 days, then you may have to make a special request with your vendor, and it may take them some work and it may not happen overnight, but they may be able to change that to, for example, 180 days out or 210 days out, whatever your preference is.
Right, which would be prudent, because the question comes up if somebody has an employment authorization document and it's not based on any employer sponsorship, does the employer have any obligation to see that they're timely applying for a renewal of their card? And the answer is, well, you don't have an obligation, but if you want to keep that worker, you're going to want to have some system in place to try to stay on top of that and encourage the worker to timely apply. On the re-verification, I'll mention that the employee, even there, has the choice of documents. Okay, so you could have somebody that had, let's say, an employment authorization document when they were hired, and let's say that might have even been based on a pending marriage-based green card. And by the time they re-up for re-verification, they've got their green card, and they want to give you a driver's license and an unrestricted Social Security card. That is their choice. So be careful, because we've seen some clients fined for violating the rule about requiring that certain documents be provided. Even at the re-verification stage, the choice of the document is the employee's alone.
And so, Penny, here's another question that came in. When someone gets a green card approved and they were previously on an H-1B, for example, when do you update the I-9? Is it when the H-1B actually expires or when the green card is received?
Yeah, there you have a choice. I mean, you're not required to do the re-verification until their prior work authorization is expiring, okay? But one reason to, especially if you've got a situation where you are aware of the person is in the green card process, such as with a sponsored foreign worker, if you go ahead and update it, then you're done. Because as Justin mentioned earlier on, you're never going to re-verify a green card holder, right? And so they're a permanent resident, and that's permanent even though their card has an expiration date, right? I think you all know this as well, but I still do get questions. With re-verification, you're never re-verifying a List B document. I'll get a question, well, this person's driver's license has expired, and what do I need to do on the I-9? The answer is nothing. The document just needs to be unexpired on the date that you do the I-9, that you do the document inspection. And there are some exceptions, because, like, for example, in COVID, some states auto extended their driver's licenses. And if that was the case, that's a valid document. Okay. There are, and we'll get into the weeds a little bit here in a couple slides, but there are auto extensions of certain types, but not all work cards. And if a card's been auto extended and the employee has the right documentation, then you can accept an expired work card in that setting. Okay, list of acceptable documents. You know, this is helpful, but it really doesn't cover all the situations, and I would commend it to you. Rule number 1, the instructions say, thou shalt make this list of acceptable documents available to the worker when they do the I-9. Okay, it's always been a best practice to have it there. To feel like onboarding is in a particular room or something, you could laminate it and have it on a table or hung up or whatever. But if you're doing an e-hire system, right, you will want to include the list of acceptable documents, and, getting ahead of myself a little bit, the instruction sheet. You're supposed to furnish that to the employee as well at the time they do the I-9. So that's more of a thing of just making sure, if you've got a vendor, that they've added that to the new hire packet. Many of those already had the list of acceptable documents because the employees needed some guidance on what am I supposed to show or upload under some of the old systems. But you know, they will want to provide that as well. Now,
Penny, I think that does bear repeating, though, just so make sure everyone heard that. The new form does explicitly state that the instructions should be provided to the employee. Just want to make sure everyone heard that.
right. Thank you, Justin. So again, let's talk a little bit about some of these expired documents again. Let's say somebody has an expired driver's license, okay, but they've applied for a new driver's license and they have a receipt for that. In many states now, because of the Real ID law and other things, they want to have the process more safeguarded. And so you go through the process to get your new license, take a test if you need to, have a new photo made if you need to, but then they mail it to you. Okay, so there's a lag there, and you can accept that. You can accept a receipt for a replacement Social Security card. The rule has long been that if you have a lost, stolen, or damaged document, that you can provide a receipt for that document. Okay, I will note that a receipt for a Social Security card says that it is a receipt for the card. It is not a printout that confirms the person's name and Social Security number. Okay, that is not a receipt for a replacement card. But the rule with receipts is you note that on the I-9 that a receipt was given, and then the person has 90 days after that in which to bring you the document. And then you fall back to the standard rule of needing to see an original document. Now, if you're using the new procedure, you could do that remote, but then you annotate the I-9 to update it, to indicate that you did the actual inspection of the driver's license or the Social Security card. Very similar to what a lot of you were doing over the last month or two in coming into compliance with the in-person inspection requirement. I-9 Central had examples of how you could put in the notes section that the in-person inspection was done by so-and-so on this date.
So Penny, speaking of that, we're starting to run low on time here. So I think we should probably move along. But I think just to mention briefly that one of the nice things about the new list of acceptable documents I would mention is they do have a link to I-9 Central, which has a lot of questions and answers, and that's a good resource, as well as the M274 handbook. And just to mention, I think briefly with the form instructions, you can take a look. They've cut them basically in half. They were about 16 pages. 15, 16 pages and down to about 8 pages. And it does include instruction on the new virtual process and clarification that you don't have to write NA as Penny mentioned earlier in all the optional fields. That's not required anymore. But we just have a couple minutes left. So let's just touch basically on the end of the
Sure.
COVID-19 flexibilities. As Penny mentioned, the deadline for coming into compliance was yesterday, and I'm sure everybody on this call is absolutely 100% in compliance. As a reminder, this was a temporary policy that deferred in-person physical inspection. That policy came to an end July 31st. Employers have until August 30th to come into compliance. And this requires doing a in-person physical verification and then annotating the I-9 form. If you're a qualifying employer enrolled in E-Verify, you may be able to use the new virtual process for the physical inspection, but you must have been enrolled in E-Verify during the COVID-19 flexibilities and created a case for that employee in E-Verify. You must continue to be enrolled in E-Verify and in good standing, and you follow that new virtual process and annotate the I-9 accordingly. Now, Penny, if let's say an employer has not been able to get all of their employee population through this process by August 30th, should they simply throw up their hands and say, well, the deadline's passed, so we're out of compliance, nothing to be done? Or what would your recommendation?
Yeah, I strongly recommend you come into compliance and do it sooner rather than later. Don't think, well, I'll do it by the end of the year. Let's do it in the next month or so. But ICE has actually come out and said that this is not going to be an enforcement priority for them, but they still can fine you. So most definitely come into compliance.
Yeah, exactly. So, and they've said, especially if an employer can demonstrate that they took steps to come into compliance in a reasonable period of time, they're going to look more favorably on that. So I think if you have not had this accomplished yet, you want to set a deadline to get it done as quickly as you possibly can. We just have a little bit of time left here, a minute. So we'll just touch on a couple of best practices very quickly here. Penny, do you want to start?
As we talked about the Monday, Thursday rule, you actually have the extra 3 days to do section 2, but do it all on day 1. Do you want to onboard somebody and orient them? And let's say if you're a staffing company, actually send them to a client site only to have to pull them 3 days later because they haven't come up with their documents. So by far, I do that. On rehires, you have an option if they were hired in the last 3 years and their documents are still valid to treat it like a re-verification. Go ahead and do a new I-9 because that way you can make sure you've done it correctly, and the statute of limitations based on the retention period is going to roll off. So I would
Patty, just sorry to interrupt you. People are asking for the code, and we are about at time, so I'm going to put the code on the screen while you talk for everyone. Go ahead.
You go ahead, Justin. I think we had 1 or 2 other tips.
I think just a couple of things to I think mention that are important to remember. And Penny mentioned this earlier. You never re-verify permanent residents and U.S. citizens, right? Just because a U.S. citizen's passport expires or a permanent resident's green card expires, their status as a permanent resident or U.S. citizen doesn't disappear, doesn't go away, right? And they are still authorized to work. So you never want to re-verify those folks. Another common question that comes up is about legal name changes. Okay. If someone comes in with a legal name change, for example, they got married and changed their name, you're not required to update the I-9 form in that situation. It's optional. But if you are going to update the I-9 form, you're going to do that in what was used to be section 3, which is now supplement B. That's where you would note the name change, and you should also obtain evidence of that legal name change and keep that document with the I-9. Now, if you have a different type of name change, which is actually a change in identity, for example, you have James Johnson suddenly, come forward as John Smith, and they have new identification with a different date of birth, etc. And they tell you, I was not authorized, but now I am. The employer can certainly terminate that employee under its honesty-related policies, right, for committing fraud in connection with their employment. But if the employee is now authorized, the employer does have the option of retaining that employee. And if the employee is retained, then you would complete a new I-9 form with the new information. You would put the original date of hire on that new form. You're not going to change that date of hire. Okay, you're going to attach the new form to the old form with an explanation as to what occurred then. Okay, and I know we had some questions about whether we're going to share these slides, and yes, we will be sharing the slides after the presentation, but we are now over time, so I think we're going to have to stop for today. We thank you very much for attending.